So we're going to call to order our first and only hearing of the evening. And this is the application of Network Building and Consulting LLC, agent for T-Mobile Northeast LLC, and Robert Jessen, who's the trustee of the building here, Atlantic Financial Associates Trust. And this application is one in which the applicants basically seek an overruling of a decision of the Milton building inspector. Mr. Jessen, in his trust, owns an office building at 480 Adams Street in Milton, which is in the business zone of the zoning bylaw. And the tenant is operating currently under a June of 2005 permit, a stealth rooftop installation of 5 antennas on top of the office building. And in the present application, the tenant is seeking to replace the existing antennas with new similar antennas and add one new antenna to the stealth installation. And they want to replace these features all within an architectural design as originally approved here by the Design Review Board. And Section 3G7 of the Milton zoning bylaw, which relates to these wireless telecommunications facilities, provides that any building permit that is issued is required to have the holder of the building permit indemnify and hold the town of Milton harmless from any and all claims, causes of action, damages, blah, 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 arising out of the construction, location, operation, and use of the telecommunications facility. This particular facility did receive the approval by the Milton Design Review Board, but I understand no written decision was ever rendered, but it has been approved, and we're going to treat it as approved. And the applicant is contending here, and Mr. Moran will address this in greater specificity, that the indemnification provisions of the Milton zoning bylaw are in excess of the building commissioner's authority, not authorized by the Zoning Enabling Act, and that it violates the Federal Telecommunications Act by seeking to impose an impermissible, quote, barrier to entry, close quote, in violation of the Act. The building commissioner would have issued the building permit if the written indemnification had been provided. So that's a fair summary of the application. My name is John Leonard. I'll be acting as chairman for this particular hearing. With me this evening to my immediate left is board member Brian Hurley, and to my immediate right is board member Frank O'Brien. The rules of the board are such that we'll first hear from the applicant. We'll hear from any persons present who wish to speak in favor of the application. We'll hear from people present who have questions of the applicant, and then we'll hear from anyone present who may seek to oppose this particular application. In addition to the advertisement, which I have at least summarized into the record, we have the application of the applicant, which is dated 12/3/2012, and we'll have all of these documents as part of the record, so we won't have to get involved in formally marking or offering documents. We have an 11/15/12 letter of Mr. Prondak to T-Mobile Northeast regarding the application. We have a hand-delivered letter from Martin Cohen of Network Building and Consulting LLC with respect to the application, filing the application, filing a memorandum from Attorney Peter Moran, and other materials that may be relevant to the application. We do have an opinion letter by Peter B. Moran of counsel at McDermott, Quilty and Miller, 131 Oliver Street, Boston, Massachusetts. It's dated, it looks like December 3rd, but the date probably isn't too relevant. It's been stricken here. But it relates to the application and the reasons why the applicant believes that the building inspector is in error in refusing to grant the building permit. We have the building permit application and the check for a substantial sum dated 8/17/12 for the particular application. We have a workman's compensation affidavit. We have a a license of Wayne Scott in Beverly, Massachusetts. I don't happen to see him here this evening. We have a certificate of liability insurance from Network Building and Consulting with respect to liability issues relating to the particular project. We have a letter of authorization from Mr. Jessen dated June 13th, 2012. And we have a series of plans with respect to this proposed facility. The plans are in multiple pages. They're by Hudson Design Group of North Andover, Massachusetts. They are dated 5/30/2012. Looks like it's in 3 or 4 sheets. And we have a series of photographs supplied by the Network Building and Consulting LLC showing the particular building, showing the facilities that are in place, showing the facilities as proposed. And we have a removal bond for the removal of the facility if it's permitted to be expanded, signed by T-Mobile Northeast. So with all of those formalities out of the way, are you Mr. Moran?
I am.
Good. Well, welcome to the Board of Appeals, Mr. Moran. We're delighted you're here.
Thank you.
And we're delighted to hear from you. The floor is yours.
I'm delighted to be in the town of Milton town offices for the first time ever. I have been doing zoning work since I graduated from law school in 1981, and I've been doing wireless zoning work since shortly after the Telecommunications Act of 1996 passed. And just to show the passage of time, I used to represent American Tower when Marty Cohen was the zoning counsel for American Tower, when we both had dark hair. So a lot of water has gone under the bridge, and what's really interesting to me is, as you're all, as I have done my research, you are all lawyers, and so I know that you all appreciate when an issue that you've never seen comes along, and you actually, it re-energizes your love of the practice of law. And I have to say that in the 14 years that I've been doing zoning work in the wireless field for Sprint, T-Mobile, American Tower, Metro PCS, and all of the others, I thought I had pretty much seen everything until I ran across this particular provision. And it's so unique that it precipitated a number of more than lengthy conference calls with the National Zoning Council for T-Mobile, who's in Seattle. And he's been at this for, since the Telecommunications Act passed. And in the country, he's never seen it before. And now Marty tells me this morning that, curiously, Milton and Quincy, its neighbor, have almost the identical provision. And we speculated as to what particular event may have precipitated the town meetings of Quincy and Milton to adopt this. I had suspected, as just out of reflex, that it might have arisen out of the sort of general town meeting, I don't mean this pejoratively, concern or hysteria over the health effects of wireless communications devices. And then it occurred to me that it might have arisen out of an experience that this town had with industrial communications. So I'm curious if the board can educate me what the precipitating event that created this. But that's not why we're here. Why we're here is to determine whether or not this is a provision that the Zoning Enabling Act empowers a town to adopt as part of its bylaw, and we contend that it doesn't. I don't want to read through my memorandum or restate what's in the letter. I'm sure you've had a chance to review it. I think essentially what makes this unique is that this is an attempt to require unilaterally the imposition of a contractual term as a condition of exercise of zoning authority. And when you look at the Zoning Enabling Act and look at the definition of zoning, it's clearly not explicitly stated in the Zoning Act that that municipalities are empowered as an incident to the exercise of zoning power to require particular contractual terms or other thing. And from the nature of the language in this, that goes not just to the indemnification of this board or to the town as a result of its exercise of zoning authority in granting the permit, but it's to indemnify the town for anything that might arise at any time in the future as a result of the mere presence of this facility that was permitted by the town at a particular time in the past.
Right, the indemnity says construction, location, operation, and use of the facility.
Right, and so it has nothing to do with indemnifying the town for what it does in the exercise of its zoning authority. It is purely one of the discussions that took so much time with the T-Mobile Council was to imagine what possible circumstance might arise where this indemnification would occur. And, you know, as lawyers, we say, well, you know, we're both trained to consider the most outlandish what-ifs and also to ridicule them as being beyond the realm of feasibility or likelihood. But unfortunately, in this case, and the greatest concern that T-Mobile has as a private corporation is this provision calls into question whether or not a facility under this kind of indemnification could be financed, or whether it violates lending covenants. I have sought to get that answer from experienced commercial lenders and commercial lending counsel, and I've gotten a lot of head scratching as a result, which at the very least would be inclined to delay or postpone a loan commitment for financing construction of this type. You know, in any event, I was rather a little bit surprised to learn that the position of T-Mobile is that under no circumstances would they agree to this kind of indemnification, even in light of one of their competitors, Metro PCS's apparent eagerness to provide just this indemnification. And so when I ascertained from my other client why they did that, the response was, we just got our license from the FCC. We were in a hurry to get our network built. We didn't care what we signed. So there's quite a wide disparity in the attitudes of competitors with respect to this kind of thing. In any event, I don't, at this point, now that I've sort of explained the background and the reason why we're here, instead of giving you an oral argument, I suppose it'd be appropriate for you to exercise your position as quasi-judicial officers and grill me or discuss it in however you'd like.
Sure, we won't be grilling you,
Yeah.
but we may have some soft questions to throw your way.
Yes.
And I guess the first question that I have is, I read your memo, which I think is very well done and took a lot of work and is well researched. But in reading the memo, I didn't come across any case which particularly held this indemnification clause in the bylaw to be unconstitutional or in any way imposing an effective prohibition
Right.
on the applicant.
Right,
So it seems to be a question of first impression.
yes.
You know as well as I do, because you've been an attorney for so many years, that the bylaws are presumptively valid, and you've got the burden to show that they are invalid, and some commentators suggest that that's a rather heavy burden. But let me ask you this. You know that there are many other telecommunications facilities all over Milton. And do you understand that they have provided the letter of indemnification that the bylaw requires?
Well,
Other than the one
yeah.
carrier that you mentioned.
I don't know. The extent of our research is only that the Metro PCS facility is a facility that was permitted since the bylaw change went into effect, which was 2008, I think, or 7 or 8 or 9, I guess.
I think that's right.
And we're not aware, we haven't been able to, we know that T-Mobile has not permitted a facility in Milton since then, and that they haven't. And we know that there are other carriers that permitted prior to the bylaw and haven't, to our knowledge, run into it at the renewal stage. But that's not research that I would take to the bank.
No, I understand. Let me ask you this. You mentioned in your opening statement that you thought that the issue was one of the bylaws seeking to involuntarily impose
Yes.
the indemnification on your client, as opposed to your client negotiating an indemnification with the town. So is that the real rub, as you see it here, that it's being imposed on you rather than being sought from you?
Well,
Because I guess it's a distinction without a difference, because you've just told us that if we did seek it, you'd say no.
well, no, actually, there is a middle ground. Unfortunately, I don't think the language of the bylaw provides either one of us with the latitude of finding a middle ground. For instance, it is certainly, it's almost usual or a custom for, well, I shouldn't say it's a custom, but there would be no objection or concern with T-Mobile indemnifying the town against the cost to the town of an appeal brought by a third party as a result of the granting of this approval, which really doesn't mean a whole lot, because in the practical course, when the board, I think this board acts as others do, when the board approves a permit and the permit's appealed, the applicant defends the permit, and to the extent that there's an expense to the board, it's a nominal expense of town council monitoring the process or whatever, but it's really up to the permit grantee to defend the permit and carry the burden. So, that kind of indemnification against the cost or the result of the exercise of the regulatory authority is one thing, but this sort of goes well beyond that, and I'm not sure how to get past that to something that's more that gives the town more comfort that's even definable, because once you get to the point where we would have to do if the industrial communications tower fell over and killed 44 people in a golf outing at Quarry Hills, and 44 families sued the town of Milton for granting the permit for a 190-foot tower, that's an expensive lawsuit to defend, even if it's frivolous or subject to summary judgment. So, I mean, there's...
Isn't the answer to this, maybe I'm dead wrong, you filed a certificate of insurance, of liability insurance with limits of $1 to $2 million, and it goes up to, looks like $9 million in the aggregate.
Yeah.
Isn't this type of indemnity something that is usually and customarily insured against, and all you really have to do is add the town of Milton as an additional insured to your rider of insurance? There's no big money involved in this. I thought it was something that was customarily done. Could you
Well,
address that? Is that a-
The insurance certificate is yes, the insurance certificate is natural, and I think in the, 14 years or whatever, that the certificate, there's never been a claim, right? The practical likelihood of there being a claim, but the problem with adding the town as an additional insured is our liability as the property owner is one thing, but there is no, I'm not sure that the insurer would, if you presented the insurer with the indemnification language, which has never been done before, whether the insurer would agree to the endorsement.
Well, but you haven't done that as of the present time. Is
No.
that fair to say? Okay. Let me ask you this, and I don't want to get involved in your privileged and confidential matters with Mr. Jessen, the owner of the building. But isn't it fair to say that the lease that's in existence now already has an indemnification clause? You're indemnifying the building owner for these same risks of liability, and yet you seem to be reluctant to, or refusing to, give the same type of indemnification to the town. And let me say this, because I really don't want to be unfair to you, because I did take a look on the internet this afternoon to try to see how these issues were regularly handled. And when you put in T-Mobile Northeast LLC leases, you must have 15 or 20 leases by and between various people, some as late as 2010, all of which are signed and in effect, in which T-Mobile does indemnify the landowner for all kinds of risks of liability. And the indemnification in one that I was looking at, which dealt with the Montgomery County Public Schools, which is a 2008 lease, indemnified the landlord, the staff of the landlord, employees of the landlord, volunteers of the landlord, business invitees, students who happen to be present, family members and guests from virtually any and all types of damage which they may suffer as a result of the facility. And I didn't copy these leases because they're 30 pages long and all of that, but what's the big deal with complying with the bylaw here if you customarily are granting this type of indemnification to landlords and owners of property?
Because those indemnifications are related specifically and exclusively to the use of the property and to people that are present on the property.
Sure, and you insure against those risks, don't you? I'm sure a good practice would be that you
Yeah.
do that.
Yeah.
And yet, you don't think you could insure against this risk that in the bylaw? You don't seem to have considered that.
Well, no, I don't. Have we asked our insurer if they would insure against this risk?
Yeah, and if so, how much is it going to cost me? How much extra? That's something I'd really like to know.
I would like to know it too. But as you have addressed the practical aspects of this, which I appreciate. This really does come down to a pure matter of legal principle of whether T-Mobile is willing to accept the imposition of an indemnification provision as a condition of the issuance of a permit that it is otherwise entitled to as a matter of law.
Okay, I've asked enough questions for the present. Let me see if my colleagues have any questions. Mr. Brian Hurley, please.
Sure. Peter, if I understand this, your argument is that this provision is unlawful.
Yes.
And you're asking us, in effect, to declare that it's unlawful.
Yes, yeah.
What's the source of our authority to do that? Because I can't find it. It's certainly not in the statute, and it's certainly not in the bylaw.
Well, the source of your authority to
declare...
your oath of office.
Is that it? Is that?
That wouldn't be
That's it.
enough? I mean,
I mean, there's an appeals court case back, a pre-48 case,
Yeah.
that said that we don't have authority to do that,
To what?
to declare town meeting bylaw provisions unlawful. And
Well-
if you read the Massachusetts zoning manual, they certainly suggest in there that we don't have authority to do this.
Okay.
What you're asking us to do.
Right.
What they say is you ought to go to the land court and bring a 240-14A case, or
Well-
go to the Superior Court and bring a declaratory judgment action. But I don't see how we have authority to do what you're asking us to do.
Okay, I appreciate that question. And let me tell you why I'm here. Why I'm here is that I had two very collegial conversations with Mr. Prondak. And when we initially discussed it, I said, geez, this is a really tough situation that we're in, because if you're going to insist on this, I got to go to court. And he said, well, why don't you appeal it to the zoning board, and let's see if we can take care of it that way.
Well, you have
Now-
to do that as a condition precedent. to go
Well,
to
I'm not
court.
sure, I may have had to, but I may not have, because I could have gone right to federal court, if I could have gone right to.
I don't think you'd stay there very long if you had no decision on the, from the building commission.
Well, I did. I would have had it. I had the building commissioner's denial. So, under the circumstances, I was, well, Mr. Prondak is a reasonable fellow, and he suggested that the Board of Appeals is staffed with reasonable fellows. Let's do that first. Let's see if there's a way to avoid litigation with the town of Milton. So that's why we're here. Now, the answer to your question is, and I say this out of personal conviction as the chairman of the zoning board in Situate. My oath was that I take an oath to apply the zoning law and to consistent with state and federal law and the United States Constitution. Now, it is not. If I am in a position of such as this, where, and I did this last month, where I believe that the literal application of the zoning bylaw would result in an unconstitutional taking of someone's property, I have an obligation to interpret and apply that bylaw to be, so as to be consistent with the Constitution as I understand it. That's how I read my obligation.
And you agree to make that finding, you have to find beyond a reasonable doubt that the provision is invalid.
I don't think that's the standard.
Well, that's what the Burnham versus Board of Appeals of Gloucester says. I can give you the site.
Okay, all right.
But it says that every presumption in favor of a zoning ordinance and its enforcement will not be refused unless it is shown beyond a reasonable doubt that it conflicts with the Constitution or an enabling statute.
Okay,
That's a tough standard.
sure, all right, yeah,
Okay.
okay, accepting that standard, yeah.
Mr. Hurley, do you have any more questions?
No, I don't.
Mr. O'Brien, please.
Mr. Hurley asked my question.
Yeah.
I mean, first of all, I appreciate you bringing this matter before the board, because it is, for those of us who went to law school, the legal gymnastics and whatnot, it is a fascinating issue.
Yes.
But I find myself coming down with the reasoning of Mr. Hurley, in that I don't see where this board has the requisite authority to substitute its judgment in total for that of town meeting in terms of passing a valid and approved bylaw. I think that, quite frankly, your relief is, you will punch your ticket, but your relief is going to be found in front of a judge. Fascinating issue, everything else. But I, for one, am uncomfortable with declaring a bylaw totally invalid without, I mean, this is an excellent memo, an excellent letter, and I applaud you for it, but I have not seen similar work from someone else defending it. And I'm uncomfortable making a decision, validating a bylaw without having having it fully argued and with very grave doubts about our authority to do so.
Okay, well, Mr. Moran, do you have anything else you'd like to add to your presentation?
Well,
Because then we'll go on and we'll give you a chance to sum up if you
Sure.
like.
No, actually, there is one alternative to this that I'd be remiss if I didn't. It's in the letter, but the one possible safety valve here with respect to crystallizing what the issue is whether or not the requirement of the letter as a condition of the issuance of the permit is consistent with the plain reading of the bylaw, which says that the building permit issued shall require the holder.
Right, but if you say you're not going to apply the indemnity, what's the sense of issuing a permit and then revoking it because you don't? Isn't that an exercise in futility? If your position is we're not going to give you the indemnity under any circumstances, it's an intellectual exercise that gets us nowhere.
Well, okay, the result, I suppose, perhaps giving away a card in my hand, the result might be different in terms of how the zoning board interpreted and applied the bylaw. But you're right. The net result is the building permit issues. The building permit has a condition stated in it that no work shall proceed until, and then the litigation commences. So in either way it comes down, it is, bound to be a case that a court has to decide.
Okay, let's do this. Stay right there, please. Well, let's move on with the hearing. And let me ask, is there anybody who wishes to be heard in support of this particular application? And the record's going to indicate there's no support for this application. Is there anybody who'd like to be heard or have a question of Mr. Moran regarding the application? And I see Mr. Prondak there. Mr. Prondak, do you want to be heard?
I would like to be heard, yes.
Well, welcome to the Board of Appeals. Thanks for coming back at night.
Same to
Happy
you.
New Year to you, sir.
For the record, Joe Prondak, Building Commissioner for the Town of Milton. I believe I'm a bit confused as to the actual, Mr. Moran made a statement as to when this portion of the bylaw was adopted, and I believe you said 2007, 2008.
I was just trying to guess from memory.
I believe it was before that because my memory's a little foggy, but I started here in 2006, and I remember much of the zoning, coming in new to the town, I needed assistance with, and I remember Aaron Henry, former planning director, mentoring me on a lot of, and I do remember some conversations we had about the indemnification letter and how that was necessary, not to issue a permit. We may have looked at one or two, and I didn't see any. I didn't see anything outrageous about it, and just took Mr. Henry at his word. I didn't find any further need to research it, and I just took Mr. Henry at his word that this should be a practice. I have, for purposes of tonight, I have gone and copied several letters of indemnification that we've received since 2008.
And these are from
These are
telecommunications
from
applicants?
various other telecommunications applicants. I did not go, unfortunately, my file system doesn't allow me to just pull up wireless communications antennas and go in and pull out all the documents. My wireless communications antenna permits are mixed in with, permits to put additions on hospitals and remodel bathrooms. So it would be a monumental task to go and try and find all of these. But just as an example, Mary, you can have that. Does anyone else need one? Basically, it's been a long-standing practice to require this letter. I haven't received any opposition from any other carrier in providing this letter. I would, Mr. Moran, on a conversation that we had, a very cordial conversation that we had, I suggested that he come to the Board of Appeals as a matter of practice. I didn't suggest that under the thought that there might be
Relief? No,
a pending lawsuit in federal court or
Oh.
anything like that. I don't think I was even aware of that.
okay.
I just suggested that, I'll deny the permit, and you have the right to go to the Board of Appeals, as is common practice. I would, just, for informational purposes, it is generally my policy, when somebody appeals my decision, if the board finds in favor of that petitioner, that I typically change the practice. I wouldn't say I do that, I wouldn't want to say we're going to do that all the time, but typically if this board finds that, I have erred in some way, I put great value in that and typically try to change the practice. And I believe that's what I would do here. A lot of what you guys do is way over my head. I'm not an attorney. I guess the one question that I see as pertinent from my point of view, and I think Mr. Moran in some ways is asking this, if there were no letter and I were to issue the permit, does the fact that the bylaw states that the company shall indemnify the town, is the indemnification in place anyway, without the letter?
Well, now you're asking questions like a lawyer.
Well, no, I'm hoping it's just, as a building
And maybe
inspector,
people at town meeting would say, when did Joseph Prondak turn himself into town meeting? I'm sorry.
I've got a couple, just,
Of course.
So-
Have you finished, Joe? or-
I think so. Just one other thing, the permit application is for 5 replacement antennas and 1 new antenna. I definitely did err in the beginning of this process where I treated them all as new antennas and was gonna charge a fee based on the new antennas. Typically, if a wireless company comes in to replace existing antennas, we simply have them get an electrical permit. So I would suggest to Mr. Moran that if his client needed to, they could replace 5 antennas with an electrical permit. And the only question here would be the one new antenna that we're asking for the indemnification letter on.
Okay.
That's it.
Question?
Mr. O'Brien?
Joe, first, I think you as building commissioner have acted correctly and appropriately in following the course of action that you did. You looked at the plain language of the statute, plain language of the bylaw, and acted accordingly. I think that the issues that are raised by Attorney Moran are of legal consequence, and that the average normal non-lawyer person wouldn't give it a thought to. So I wouldn't suggest that you've made any mistakes in that regard. My question to you is have you touched bases with your colleagues in Quincy? Because Mr. Moran suggested that Milton and Quincy have a similar provision in both of their telecommunications bylaws. Has the practice in Quincy been relatively similar has the practice in Quincy been similar in the language, the indemnifications, similar to what we've had in Milton?
I have not contacted anyone in Quincy. I forgot that they do in fact have a similar bylaw. As you know, I did work there for 18 years before I came here. But the answer is no, I haven't reached out to Quincy, but perhaps I could. I simply don't remember if that's what we did or not.
Mr. Moran, does T-Mobile have facilities in the city of Quincy?
Never, they've never been required to provide that
Because
indemnification.
you don't know when their indemnification clause came
I
into
don't,
being.
I don't.
And they may take the same view that Mr. Prondak suggested, that they don't need a letter because it's inherent in the...
Could. All I can tell you is that it's never arisen, the issue's never arisen. But I have no reason to think that T-Mobile is taking a different position in Quincy than they are here.
Do you have any further questions, Mr. O'Brien?
The permitting issues in Quincy are a whole lot different. It's usually the hysterical neighbors that we have to deal with in Quincy.
Mr. Hurley, do you have any questions of Mr.
I don't
Prondak?
have any questions, thank
Okay,
you.
well, thank you very much, Mr. Prondak. We appreciate
Thank you
your
very
coming here
much.
tonight, and look forward to seeing you again soon. Why don't you grab a seat? Let me ask, is there anybody present this evening who either has questions of Mr. Moran or wishes to speak in opposition to this? Yes, sir. What, do you want to come up and have a seat?
Sure.
Terrific. What's your name, sir?
My name for the record is Ken Caldwell. I'm in a butter. I live at 23 St. Agatha Road, and I'm a town meeting member from Precinct 6.
Welcome to the Board of Appeals. I
Pleased
think
to
this
be
is
here.
the first time you've been here.
It is.
What have you got to say?
I have a number of questions relating to some of the things that you've been discussing, indemnification, the role of the building commissioner, and others. I won't belabor some of these points, but I know that that a license was issued, and I'm not sure of the exact date, it may have been 10 years ago anyway, to John Sheldon when he still owned that building, to put the towers there, the towers that are currently in place. I'm just wondering, were there any, in that agreement, I'm not sure that, I don't think it came before the Board of Appeals at that time, but was there any issue relative to indemnification and any issue with regard to the role of the building commissioner?
That's interesting because I asked that question this afternoon, and we have not been able to locate any file, to the best of my knowledge, that dealt with that particular issue. And,
Because it seemed to me, and again, I'm not a lawyer, just a layman, but it seemed to me that these were legitimate questions, that indemnification should be something addressed in a contract or in an agreement or approval of this request, indemnification for the town. And secondly, the issue of the role of the building commissioner, because as I read the announcement of the hearing, it seemed to me that the building commissioner was being barred from inspecting or having access to these panels.
the facilities
Yeah.
up there. No, I don't think that's the case at all. What has happened here is, under the particular provisions of the zoning bylaw that are applicable here, the applicant is saying that, number one, the statute, the town meeting bylaw cannot so provide as a matter of law, but he's also doing that in the context that the building commissioner has erred in interpreting the bylaw to require this type of indemnification. And what he's seeking to do is have the board agree with him that the bylaw, paragraph 7, dealing with indemnification is invalid as a matter of law. If the board so ruled, if we could rule, Mr. Hurley has serious questions whether we could, then of course the indemnification issue would go away and the permit would issue. So under the bylaw, the building commissioner is a first line of defense, and he's our first person who interprets the bylaw when an application is filed. But if anybody disagrees with his interpretation of the words in the bylaw, they can come to us, and then we give our interpretation as to what the bylaw says. And under certain circumstances, and I'm not suggesting this is one of them, we could order a permit to issue, a building permit, a special permit, a variance to issue. And if anyone disagreed with that, they could go to court and appeal. So that's what's happening here. Essentially, they're just saying that they think Mr. Prondak should have issued the permit.
All right. I just had a couple of other questions. These, for myself and from neighbors who expressed some concern around this issue. these, for the most part, pertain, I think, to health concerns. I think that many people feel that this issue is, the jury is still out on this issue. I'm not sure whether it is or not, but I did check on some of the proponents and some opposition to these kinds of panels, and it seems to me that the issue is one that, although not made clear at this particular point in time, is that there are concerns that people have, not so much by the fact that maybe only one or two or three panels, one location has been set up to help transmit. And as I recall, this was the very first case in which these kinds of terminals were placed in the town, towers. But there is a concern, a lingering concern around the issue, not so much about maybe one location, but about an area in which there seems to be several of these towers located. And I think we're familiar with the fact that in the town of Milton right now, the East Milton area is pretty well saturated with these towers, not just at the location in question here today, but we're all familiar with the tower that we discovered going up in 24 hours over on the edge of Cunningham Park. You've got the terminal, you've got the panel, I think, or tower down at the post on Granite Ave. 14 Franklin Street also has put up panels of some kind. None of these, as I recall, required any action by this board. But there seems to be a saturation point that we may be reaching. The Board of Selectmen approved 4 or 5 panels on Highland Street a week ago in their meeting. So it's an issue of how many panels are we going to need, how many reasonable here in the town, particularly in the East Milton area.
Yeah, let me just say this, Mr. Caldwell. Number one, I think you see a proliferation of telecommunications facilities in the square because the square is essentially a commercial area, and they're trying to avoid the objections of residential properties and residential dwellings.
But that doesn't mean the concern is not present.
No, and I know that some people have voiced the concern, but from my view, and I'll certainly let my colleagues speak to it, there's almost universal opinion in all of the federal decided cases that the fears of microwaves or cancer scares and the like from telecommunications facilities has little or no merit. At least it hasn't been proved to have substantial merit.
The jury is still out.
Well, it may be out, but until the jury comes in with some definitive evidence, it's not a good ground under the Telecommunications Act to be denying
Telecommunications Act prohibits,
permits.
I think, appeals around the issue of health concerns.
Well, that's right, and I think because they believe the science hasn't gone that far. Does anyone want to refer to that issue,
Well,
Mr. O'Brien?
I think we have that, so this is a unique area in terms of what this board does from a zoning point of view, because you have the interplay of the Federal Telecommunications Act with the zoning statute and the zoning bylaw. So it's a little bit of a balance of the equities relative to that. And quite frankly, our hands are tied on some issues, the alleged health concerns being one of them, particularly from the point of view of the Federal Telecommunications Act. The other thing that you mentioned, the proliferation of these cellular facilities in the East Milton area. And John mentioned the commercial nature of the square. Also, it is an area that multiple engineering studies have shown to be one that is beneficial to the cellular companies to putting in their towers in that particular area. And then thirdly, our zoning bylaw is designed specifically to avoid the proliferation of independent cell sites throughout the town. It's written in such a way so as to encourage these cellular companies to co-locate, expand, look to existing facilities in order to place their equipment, as opposed to going to different places and building brand-new facilities. And that's one of the things that this board looks at. Can you put that tower in an existing facility as opposed to building a brand-new tower? So that's one of the reasons why you see that. And I've sat on a fair number of these cases, and all of those all those cellular towers that you've seen in the square and else in the town have gone before this board and have been vetted very, very thoroughly. There are a few issues, some cases involving particular properties in this town, large ones who get a lot of attention, but from a zoning perspective, the cellular cases are the ones that get the most attention from this board.
I think Frank is 100% right. And the other thing why you see such a proliferation in the square is you can conceal the panels and the antennas in a much more effective way. You don't have to put up large monopoles. You can put them in chimneys, and you can tuck them in. So you're right. If you drive through the square, unless you're looking at all of the buildings, you wouldn't see a lot of the telecommunications facilities that are there. But that's one of the other reasons. If they weren't there, then you'd start to put monopoles in St. Agatha's Road and all of that, and the neighbors wouldn't like it, and it wouldn't be in the best interest of the town. Do you want to weigh in on this, Brian?
No, I think Frank covered it well.
So do you have any other questions, Mr.
Well,
Caldwell?
nothing else. It's,
Okay, well, look, thank you very much for...
We don't want to cut you short. I mean,
No,
we're here to help.
is this may not be the appropriate board, but isn't the Sheldon building, or the Jessen building now, operating under I noticed in your note here that they were business zoned, but I thought that they were, I'm not sure what the terminology is, but that they were,
They're a non-conforming use, and they're actually in a residential zone, but...
it's a residential zone.
So they're a pre-existing non-conforming use in that residential zone? Is it?
Well,
I don't know. I don't know the...
no, I think they were given authorization to operate. John Sheldon built that building. It was felt that that piece of property, which formerly had been a private property, the large orchard out in back, could not be used for a residence. And so there was an exception granted, but they continued to conform to certain agreed upon restrictions relative to the use of that property.
Yeah, all I'd have to tell you is I'm not
Okay.
familiar with
All
the
right.
specifics.
No, that's all I have.
Great, thanks, Mr. Caldwell.
Thank you.
Thank you.
Let me see, is there anybody else here who wishes to be heard with respect to this application? And there's no such person present. So, Mr. Moran, do you have anything else you'd like to say? Or if not, what we'll do is we'll end the evidence portion of the hearing, and we'll consider your application here in open session and vote on it.
No, I think this has been fun, and I appreciate having this issue to introduce me to this board, and I look forward to you doing your business, and hopefully we'll try to avoid the repercussions.
Okay, well, let's see what of course, the board hasn't made up its mind on this application. All we've been doing is asking questions. So let me see what our colleagues feel. Mr. Brian Hurley, please.
Well, I mean, consistent with my questions of Peter Moran, I do not believe, as a matter of law, that we have the power to, in effect, overrule the town meeting. I just don't see where the source of that authority would come from. And the only cases that I could find that address the issue suggested to the contrary, that we do not have that authority. It's certainly not in the bylaw, it's not in 40A, and so I don't think we have authority. But so as not to let the decision hinge solely on that, and picking up on a point you made earlier, John, I don't think, I'm not persuaded, even if I had that authority, that this particular bylaw provision violates any of the various acts that the applicant has referenced. I think there's some pretty persuasive evidence that the imposition of this indemnification is not a barrier, because it hasn't served as a barrier to any other carriers in the town. They've all very willingly signed these agreements. So I really don't understand the barrier argument. I don't, and I hasten to add that I thought Peter's memo was excellent. I think some of the issues that he raises are interesting. But based on the evidence that's before this board, even if we had the authority, I wouldn't be inclined to sort of rule as a matter of law that this bylaw provision violates either the federal or state constitutions or the Telecommunications Act or the Zoning Enabling Act or any other act that you can think of. I don't see that the evidence supports a finding by us that this is an unlawful bylaw provision, even if we had the authority to make that determination. So my inclination, clear inclination, would be to vote in favor of upholding Mr. Prondak's decision, requiring as a condition to the issuance of the building permit that an indemnification agreement be signed along the terms set forth in the bylaw.
Mr. O'Brien, please.
I adopt my colleague's reasoning and decision. I believe he's hit the nail on the head, and I would vote in a similar fashion.
Okay, well, I agree with my colleagues. I'm sure you're not surprised at that. I think the cases that I've read, and I wish I had an opportunity to read several of the cases that Brian suggested, indicated there's a strong presumption of validity in the bylaw, and that if you have to be able to establish beyond a reasonable doubt that there's some constitutional or statutory infirmity, I don't think that that burden has been met. But in saying that, I really want to congratulate Attorney Moran. His legal memorandum is excellent. It's I think it's the strongest arguments you could make under the circumstances. I think a case in point doesn't exist, and I think perhaps for a reason, because I think that the indemnification provision here is not onerous, it's not oppressive. I think it's something from my experience, and I'll admit that I'm not an insurance lawyer and I don't interpret policies. I think this is, if there were a risk, it can, with a company the size of T-Mobile, it can be easily insured over and against with little or no cost or expense, or at least substantial cost or expense. I think this is almost an intellectual exercise. It's like a moot court presentation that you find in law school, but you don't expect to find in the real world of commerce. I don't see this as being offensive, oppressive, economically. It's certainly not intended to effectively prohibit this particular facility. The facility is probably in the best interest of the town of Milton, and it's just that for not of Mr. Moran's doing, but apparently General Counsel of T-Mobile or somebody there in Seattle wants to be difficult, and they have the opportunity to do that by appealing a decision if they want, but I think it's going to be a very expensive endeavor that I tend to think ultimately will fail, and in any event, it's the obligation of this the Board of Appeals to support our building commissioner when we can. We reverse him when we think he's wrong, which is very, very rare. And it's more important that we uphold the intent of the town meeting. I agree with my colleagues here. It would be scandalous for us to try to make a determination that this indemnification clause is unconstitutional, and it would be unfair to Mr. Prondak to suggest that he in some way has misinterpreted the bylaw by insisting that it be provided by the applicant. So with all of that having been said, and since we may have an appeal in this particular decision, Mr. Hurley, how do you vote on this particular application?
I vote to uphold the building inspector's determination.
Mr. O'Brien?
I vote to uphold the building inspector's determination.
Okay, and I likewise vote to uphold the building inspector's determination. Let me just say, Mr. Moran, congratulations on a wonderful presentation, even though you didn't succeed. I think you may not be aware of our practices here, but we prepare these decisions individually, and we don't cut and paste prior decisions. So it may take 2 or 3 weeks to crank out a decision. We obviously then file that with the clerk of the town, and then you'd have a 20-day appeal period running from that point. We'll make sure that Mrs. Fitzgerald sends you a copy of the decision as long as she has your, well, we have your address, or a new address, whatever it may be. So unless there's some further business before the board,
No, just,
Mr.
this was just a fascinating
Yeah, it
issue.
is.
Just, I found it an interesting, being able to dive into the law, every once in a while, it's nice to know where you came from, even though it could have been a moot court exercise, but.
well, so if there's nothing further to be said,
Thank you.
thank you, Mr. Moran, and
Pleasure.
the board will be adjourned. Thank you, gentlemen.